be called as each of the matters come up on the agenda in the order that they appear in the public agenda, and the speakers will be allowed for 3 minutes. There will be a signal when the time is complete, and once you hear that signal, you are asked to wind up there and then as best you can, as there is a lot of work to get through, and we can't just let it go on and on. My name is Angus Talbot. My history and background is in the law. I spent 20 odd years as a solicitor. Then I went to the bar, and ultimately I became a judge at the Land and Environment Court for 15 years. And since then I've done various consulting things, and I have been a member of other panels in other council areas similar to the Waverley Local Planning Panel. There are no apologies in relation to the panel members, but I will ask each of the panel members in turn to give you a quick rundown on who they are, and also at that time declare whether they have an interest in any of the matters that are listed on the agenda. I make a declaration that I have no interest in any matter that is listed on the agenda today. The first member of the panel that I asked to introduce himself is Peter Brennan. Thank you, Mr. Brennan.
Thank you, Mr. Chair. I'm Peter Brennan. I'm a town planner with over 40 years experience. I'm a former director of planning at Waverley Council. More recently, I sit on a number of planning panels at councils, and I've also sat on the Sydney and regional planning panels.
Thank you, Mr. Brennan. Mr. Brown, Graham Brown.
Yes, good afternoon. My name's Graham Brown. I've held senior positions in local government for a number of years. I have been employed by the Land and Environment Court as Commissioner for 21 years. And since retiring from the court, I have positions on a number of panels in the local government areas in Sydney.
Thank you.
Yes, I'm sorry, Angus, and I have no declaration.
And Mr. Brennan, did you declare any interest?
Yes, I apologise. I also have no conflicts of interest in relation to any of the matters.
Thank you, and I'll ask our community rep, Penny Mora, to introduce herself. Thank you, Ms. Mora.
Good afternoon, everybody. I'm Penelope Mora. I live in Bronte. I'm the community representative on this panel. My background is in the law, and I have a particular interest in heritage matters. I have no interest to declare on any of the matters that are being discussed today.
Thank you. Well, let's move straight into the agenda then, ladies and gentlemen. And the first matter that is listed is the application in relation to the property 48 Brown Street, Bronte. And Mia Yang has registered to speak as an objector. Are you there, Ms. Yang?
Yes, I.
Thank you. Your 3 minutes starts now.
Okay, and so good afternoon, panel chair and the members. And I object to this plan due to there are high possibility that the 8-degree rooftop design will block my view to the sea. Before I talk about my concern, I would like to indicate there are a few points in the agenda is not considered fair enough. On page 12, it presents that the number 46 Brown Street is higher than the proposed address that we're going to discuss today. However, I would like to indicate that the hill or the land behind 46 Brown Street belongs to them, so no one cares about blocking their own view. In contrast, my house at 10 Seaview Street, Waverley, sits right behind the 48 Brown Street. The roof will potentially block my sea view, so I believe the comparison above is not reasonable. And also the agenda says 50 Brown Street have a high elevation position because they sit on higher slope. Then the 48 Brown Street would be the lowest height drawing between its labor. But what I want to say is that the drawing behind number 50 Brown Street is unless 4 meters higher than my property. So the comparison is not reasonable as well. And besides, the agenda trying to say the first photo on page 22 shows the tree is tall enough to cover the roof of 48 Brown Street. Therefore, they are assuming the lower height of 48 Brown Street is not going to block my view. But I have to tell you in reality, I spent my own expense to maintain the tree height on the right-hand side of the boundary in order to make sure the tree is tall enough to cover their rooftop. No matter how I'm trying to protect the privacy for my neighbors and me, under this maintenance, the neighbor on 46 Brown Street and me could say hello to each other while they're on the first floor and I'm standing on my master room. So not to mention the DA plan of 48 Brown Street has 3 large windows opposite to all of my bedroom. And this please refer to the page 45 on the agenda. However, the privacy concern is not what I want to focus today. What I want to focus today is the 8°4 design. This design will block my view, and I believe that the view belongs to the public, but not oneself. And for 48 Brown Street, I don't believe anyone will go up and climb on their rooftop to seeking a view. That means they are not getting any view. But the 1.225 meter rooftop design will block my sea view at my lower ground floor. To be honest, I'm so anxiety about the rooftop will block my view, and obviously this will make a significant price drop for my property. And I'm afraid to take this risk during this pandemic year. And if it is happens, who's gonna take care of my economic loss due to the view loss? And at last, I'm sincerely asking the panel chair to encourage a little change on the 8° rooftop to 3° rooftop design, as same as the design on the west. Then we are enabled to enjoy a lovely and neighborhood environment for our community interest. Thank you. That's what I'm going to say today.
Thank you for your assistance, and I'll just see if any member of the panel wishes to ask you a question. Mr. Brown?
No, thank you.
Ms. Mora?
Sorry, can you remind me what rooms you have on your lower ground floor that you're concerned about the view being blocked from?
It's actually all of my bedroom is in the lower ground floor, including the master bedroom and 2 bedroom, and there are total of 4 windows. So the 4 windows will be opposite to the 48 Brown Street, and they're gonna have a huge window for their stairs. The huge window is a floor to ceiling height window, and 2 other windows face to my bedroom, and including one which have a bedroom. They got 2 windows. One is to the north and the other is to the west, which is opposite to me. So I don't think it is necessary to have such a big window for them to face to my bedrooms.
Thank you.
Thank you, Mr. Brennan.
No, Mr. Chair, no question.
Thank you for your assistance, Ms. Yang, and the panel will definitely take into account your consideration.
Thank you.
The other person who is registered to speak on behalf of the applicant is Jackie Ezza. Are you there?
Yeah, hi.
Thank
Hi.
you. Your 3 minutes starts now. You're the architect.
I am. Look, I've read the assessment and I'm very happy with the recommendations, but after hearing Mia speak, I would like to say a few things. It's pretty clear in the photos that are part of the assessment that there is a mass of trees across the back of our property. They're 10 metres tall. You cannot see the property at all. There's no privacy issue. However, if Mia thinks that stairwell window is an issue, I'm happy to put obscure glazing there, not a problem. With regard to the pitch of the roof at the front, it's part of the design. I wouldn't really be keen to change it to 3 degrees because that makes it a whole flat roof and changes the whole design. The idea of those 8-degree roof forms is to capture the north sun from the north with those angles. So I'm not really keen on that. And I really don't think there is view loss. I think the way the assessment officer has stated it and shown in the photos is clear that there will not be view loss. That's all I really have to say.
Thank you for your assistance. I'll see if there's any questions. A couple of technical matters arising there. Mr. Brennan?
No, I have no questions.
Mr. Brown?
No, thank you.
Ms. Mora?
No, thank you.
All right. Thank you for your assistance, Ms. Eza. Now, the panel will consider not only the matters that have been put to it today, but also the whole of the material that's before it when it moves into closed session, and the outcome of the development application will appear on the council's website as soon as practicable. Moving on to item number 2, relating to 79 Ocean View Avenue, Dover Heights. We have the written submission from Adam Polak, and that has been taken and will be taken further into account by the panel, and all of the diagrams and arguments that are included in that submission. Registered to speak on behalf of the applicant is David Epstein, the architect. Are you there, Mr. Epstein?
Yes, I'm here. Thank you.
Thank you. Your 3 minutes starts now.
Thanks very much. I just wanted to say firstly that we support the recommendation, and we're happy with the conditions that have been recommended. The only matter that I wanted to bring up is just on the issue of condition number 3 and 2A, which 2A we are okay with, which is to do with the requirement for no solid portions on the deck on the ground floor, and a glass balustrade. We're fine with that. The shade structure, however, is something that we were hoping to be able to accommodate somehow, even if it's just a post and beam sort of structure, which is open for the majority of the time, but would allow for some shading when the deck is in use.
This is condition 3, is it?
That's condition 3, that's correct.
Page
The deck
74.
itself is not to be used all the time. There is another open area that would be used, and that has shading, but this deck on the top floor, when it is in use, it may require shading from time to time, and it would be good to be able to provide that as a temporary form of shading. Other than that,
no structure is shown on the plans in that area. You're talking about a temporary.
Yeah, so the plan only indicates a sort of a post and beam, just a very open structure. There's no solid roof or anything of that nature. So a post on the corner and a beam across the top linking to the back of the garage would be the idea, and that would accommodate, be able to accommodate a shade structure to be attached to it.
Well, that'd need consent, wouldn't it?
It's indicated.
You're using the word structure and establishing a pole.
Yeah.
That's not part of your application.
I think there is it is shown on there, if I'm not mistaken. If I just go to the drawings.
Any member of the panel help here in terms of what I'm saying?
I would have thought that the deck where it's located in the southeast is self-shading. It's very small.
It will be partially shaded by the garage, that's correct.
I don't understand that you say that you think it's on the plans. I don't know that that's right. And if it's not on the plans, then you'd need a development application.
Okay, I think it's shown on the east elevation. It probably looks like it's in line with the structure behind it, I suppose. That's why it's difficult to read. And it's exactly the same height, and the garage as well. There's no sort of additional height. So you're looking at it in front of the structure that's behind it. That's the only issue.
There's no
I thought that was why the condition was imposed. Otherwise, the condition wouldn't have needed to be imposed. But because obviously, as you say, if it was required as a separate application, it would be an amendment.
You know, given the, as I said, it's in the southeast corner, and given the flat building to the west, don't think you'll need much shading. But
any other member of the panel wish to make an observation?
I probably would support the retention of the condition. I mean, it doesn't stop having a temporary structure like an umbrella, and I can't make it out on the plans. I would have thought if it was shown on the east elevation, it should show somewhere on one of the plans or be noted somewhere. But I would have thought a temporary structure would have been sufficient.
Okay, I guess, yeah, the only concern with that was the wind issue. Obviously, in that location, it's very windy, but we're fine with that.
All right. Thank you. Anything further? Any further questions for Mr. Epstein? All right. Thank you, Mr. Epstein.
Thank you.
And again, the panel will consider everything that's been put before it today and also in the material, and will make its decision when it goes into closed session. Moving on to item number 3, relating to the proposal at 131 Military Road, Dover Heights. The panel notes that there has been a further submission from Mr. Moody that was received in the last few days, and that will be taken into account, even though it's not listed. The applicant, Neef Ziad, sorry, Mr. You'll tell me how to do it correctly.
That's close enough.
Thank you.
Thank you.
You wish to address us as the applicant. Thank you.
Thank you. Thank you, ladies and gentlemen of the panel. I am the applicant for 131 Military Road, Dover Heights. And I just wanted to give a background. Prior to filing the DA with council, preliminary drawings were provided and shown to our neighbours at both 133 Military Road and 110 Dover Road, Dover Heights, in respect of addressing any concerns that they had. The DA that has been submitted and has been amended as such has taken into account our neighbours' submissions over the period of time. Again, I note that you mentioned that Mr. Moody has made another submission. It seems that submissions continue with all respect that they're entitled to. But we've had 3 meetings with our neighbours to address different concerns and change plans to reflect that. It was a process I adopted with the neighbours and also with consultation with council officers. Council officers addressed some of the concerns as well and wanted us to take it a bit further, which we've addressed. The application does not encroach, it does encroach on the provisions of the FSR and departs from the height requirement, but does fit in with the streetscape and the bulk of the surrounding landscape and properties within Military Road and our surrounding properties. There's no issues of overshadowing, there's no issues of view loss, and no issues of loss of privacy. Essentially, it's a sympathetic design on a difficult block that addresses the surrounding streetscape and will be a welcoming addition to the ever-changing streetscape of Military Road. I note the report of Mr. Somerville and support the recommendation of approval. And I thank you for your time.
Thank you. And your comments, as well as everything else the council, the panel has before it, will be taken into account, and the decision will be made in the closed session, and the result will appear on the council website. Thank you. Moving on to item number 4, that relates to the proposed Torrens Title subdivision at 59 Lamrock Avenue, Bondi Beach. There's been a written submission from Philip Lim on behalf of the applicant. and I think the applicant himself has made a submission, but there is no person listed to speak, so that matter will be considered based upon the written material before the panel when it goes into the private closed session. And moving on to item number 5, which relates to the proposed development at 144 Warners Avenue, Bondi Beach. The first person listed to speak is on behalf of the owner, Aaron Danziger, Anthony Boscovich. Are you there, Mr. Boscovich?
Hi, this is Kate Boscovich speaking on behalf of Anthony, who was called into court.
I see. So you're representing the alternative speaker to the alternative speaker.
Yes, I am. Thank you for having me.
All right. Are you a lawyer as well?
I'm a lawyer with no expertise in planning, so I'm just going to give it my best shot.
Oh, that's probably a good thing. It's all right. I just missed your Christian name again.
Kate, with a K.
Kate. Okay, Kate for Anthony. All right, thank you. Kate, go.
Thank you for having me. So just a bit of background. In November 2019, our client voted against a motion that was tabled to the Owners Corporation to submit the development application and the original plans to council. Subsequent to that, our client also issued an objection to the original plans that were submitted to council. I understand that council refused the original application and the applicant has filed a Section 82A review, and that application was filed through the New South Wales Planning Portal on or about 7th of August 2020. When making that application through the planning portal, the applicant has declared that all drawings, including the 82A application, all drawings have been tabled to the owners of the land, in essence, and they have obtained the owners of the land's consent to the application. Our client has made investigations with the strata manager. At no time since 7th of August to today's date has any EGM or AGM motion been tabled to give the Owners Corporation consent to the 82A application, nor has any consent been given to the revised plans. And in fact, our client submitted an objection on the original plans because they had no idea that revised plans had actually been lodged with council. So this is problematic in the sense that our client is of the view that there's been a potential breach of 10.6 of the EP&A Act by giving a false declaration through the planning portal in circumstances where in fact there is no motion to allow these plans to be submitted. So in the first instance, our client would ask that the panel defer this matter to a later point of time, where at such point of time where the applicant can demonstrate that consent has been provided by the owners of the land. Aside from that material issue from our client's perspective, our client still has some significant concerns about the proposed plans. We perceive the proposed plans in the amended form to be somewhat misleading in the sense that what we see is a study in an office being tabled to the planning panel and council, but that study in office still has an ensuite bathroom attached to it. Our client genuinely believes that these spaces are going to be used for an extra bedroom as a habitable space. So therefore the concerns that we have about the overloading of the existing services, as well as lack of garbage and waste disposal mechanisms within the building, still exist. We also have concerns about the structural integrity of the building. No structural engineering sign-off has been provided to demonstrate whether or not this building can in fact hold those dormer rooms in the proposed form. In relation to that specific point, the building is an old building. It was pre-1977. It is in the poor state of repair is terrible at this point of time, from what I understand. I've also received notice that the Strata Committee has been investigating of late the existence of concrete cancer. Now, until that is further explored and an engineering sign-off is provided, our client just believes that having the risk of having 2 additional dormers or 4 additional dormers in the upper levels could potentially jeopardize the integrity of the building. And finally, there is still significant concerns about garbage and waste disposal, and also for additional parking facilities within the building, if in fact these areas are going to be used as bedroom. And that's all.
Ms. Boscovich, there is some suggestion that the law was changed in relation to the giving of owners' consent in relation to strata bodies.
Yes.
And that it was no longer required in regard to what is effectively a modification application. Have you looked at that aspect?
I've done some investigation. I understand that the changes were made in July 2020.
This application was lodged in August, wasn't it?
That's right. But I understand that the form that's been required by the New South Wales Planning Portal is an online declaration, and that declaration is, the exact words are, I declare that I've shown this document, including all attached drawings, to the owners of the land, and I have obtained their consent to submit this application. My understanding is that that box has been ticked by the applicant, and there is concerns from our client's perspective that they just were not aware of that application. They weren't aware of those documents. They weren't aware of the amended plans. The amended plans were only filed in December 2020.
I see. Shown to owners. Did not happen. All right, thank you. I understand the submission. Not too sure whether we're a legal body, despite the background of some of us. But thank you for your assistance. I'll just see if there's any questions. Mr. Brown, have you got any questions for Ms. Boscovich? You're on mute, Mr. Brown.
No questions.
Got any questions?
No, thank you.
Mr. Brennan?
No, Mr. Chair.
And Ms. Mora?
No questions, thank you.
All right, thank you. Well, thank you for your assistance, Ms. Boscovich, and we'll certainly take into account what you've put to us when we consider it in due course, and the outcome of the application will be published on the website. The applicant is represented by either Alex Smith or Lee Cosnetta.
Yes.
Are either of those people here?
Yes, Alex Smith.
Thank you, Mr. Smith. You're an architect?
I'm the architect, yes.
Thank you, Mr. Smith.
So I'll just reply firstly to Ms. Boskovitz's comments. Just a bit of history. She represents one of the owners in the building who wanted to take the backyard for their private use, and at one of the AGMs, the owners didn't vote to agree with that, and I think there's, they're not happy about that, and they've been looking at ways to try and disturb this process.
I can assure you we'll be taking no account of that comment. Please continue.
Okay, sorry. And well, to say that it's incorrect to say that approval was not received by the Owners Corporation, and that's a matter for the strata manager, and they have been discussing it, but we did have strata manager approval to lodge the application. It's the same application as the DA. As to the building state, obviously engineering will be done at the construction certificate stage, which is normal. One of the reasons that this whole process started was because of the state of the building, and it was a way to raise money from the owners to repair the building. So that will all happen in due course. Generally, we lodged, this is a review application. The original DA was refused. We amended it twice and lodged a scheme in close contact with council planning officers that we were informed would be acceptable. And after we were also engaged a heritage specialist to be involved, which is one of the things that council planning officers wanted us to do. We amended it again after they got involved, and council asked for a zero impact outcome, which is what we've achieved because there is no increase to the roof envelope now. The use of the the attic is as what's shown on the plans, which is for home office. It's not really the size of a bedroom, but given people working more and more from home these days, it was agreed that it is still worth getting an approval with less floor space, less usable floor space that can be used as a home office. So we generally support the report and the assessment officer's recommendation for approval, and I'm here to answer any questions.
Can I just understand the process? There was originally a development application and that was refused.
Yes.
And that was all before the legislation changed.
Yes.
And the suggestion that I understand Ms. Boscovich to be making is that that original application did not properly have owner's consent.
Yes, which is not correct.
Well, but I understand her submission as you do.
That's what she's saying. Yeah.
And then subsequently, after the legislation was changed, the review application was made in August.
Yes, I have to check the dates, to be honest. But
yeah, but it was subsequent to the change in legislation that we're now discussing, I presume, because it was in August.
I believe so, yeah.
And the review application did not have any owner's consent.
I need to check that, if it was required or not.
Not a question of whether it's required, we'll have to decide that, but the question was, did it purport to have owner's consent attached?
It was the same consent because it's attached to the DA.
Yeah, so you were relying on the prior consent?
Yes.
All right, thank you. Any other questions from panel members? Ms. Mora?
Yeah, Mr.
No, Ms. Mora. Penelope?
No, I don't.
All right, thank you. Now, Mr. Brennan, it's your turn.
Yeah, just a quick question to Mr. Smith. The bathroom, in effect, is just a water closet with a hand basin, is it not?
And a shower.
There is a shower.
Yeah, so if you're looking at the plans,
it's very hard to see.
In units 3 and 4, where there's sort of like a big X next to the toilet.
It looks like a hand basin. It doesn't look like
So, for example, unit 4, you walk into the bathroom, there's a hand basin on the right, then there's a toilet, then there's a shower.
Okay, right. The shower's not clearly shown. Okay.
I'm looking at my plans, not the report, but I can just check against that.
The plans I've got don't show a shower unless there's a faded line there that I can't see. Okay, you say there is a shower there.
If you look on page 226, is that the one you're looking at?
No, I was looking at the plans.
Yeah, the plan
that accompanied the application.
1, 2, 3, 4, 5, 6. They're not numbered.
Drawing 06, and on the report it's
06, drawing 06.
Yeah.
Yeah.
Oh, actually, you can see it more close up on drawing 04.
Okay, right. I was looking at the A4 plans that, the A3 plans, I should say, that were provided by the council that are coloured, and it doesn't show on that. But I see on the smaller ones there is what would be indicated as a shower recess. Okay, thank you.
Mr. Brown?
No questions for me, thank you.
Yes, thank you, Mr. Smith. Now, are we also blessed by Mr. Cosnetto, or is it you're doing the job?
Unless he wants to add anything.
Is he here, is he?
He was.
Afternoon, Chair.
Oh, Mr. Cosnetto, would you like to say something?
I believe everything was covered, Mr. Chair, but I might just suggest that the comments raised by the objector in relation to waste and parking, the transformation of these units to include a study doesn't generate any additional waste requirements or car parking requirements under the Waverley DCP.
Thank you. No questions for Mr. Cosnetta? Thank you, Mr. Cosnetta.
No.
The panel will take everything that's been put to it into account when it moves into closed session, and the outcome will appear on the council website. That takes us to item number 6 on the agenda, and that relates to the proposed development at 30 Yanko Avenue, Bronte. And the first person listed to speak on behalf of the occupants of 28 Yanko Avenue is Mary Ellen, the architect. Are you there, Mary Ellen?
Yes, I am.
Thank you. Your 3 minutes starts now. Oh, Mary Ellen Hudson. They missed out Hudson on my sheet, so I'll correct that by addressing you properly as Miss Hudson.
Okay, I'm just having issues with my video. Sorry.
Well, we can hear you clearly.
Okay. Yes, I'm the registered architect and speaking on behalf of Jennifer and Glenn Atkins, who are the owners of number 28 Yanko Avenue. And they are the neighbours directly to the east of 30 Yanko Avenue. In assessment of the application, our concerns were that the elevated decks to the rear living area and proposed upper level bedrooms, the excessive height and overall bulk of the proposed upper level addition, the general loss of privacy and amenity. The proposal doesn't address the relevant general objectives of the DCP. The scale of the proposed development is not appropriate. It's well over the height limit for both wall heights and overall heights, and it's over the FSR. The existing elevated deck off the main living level already overlooks the private open space and the pool area of 28 Yanko, and it already sits approximately 3 metres above ground level. The proposed extension of this deck will only further diminish their privacy. The proposed upper level balconies off the bedrooms are also directly overlooking the rear private open space and the pool area of 28 Yanko. Privacy screens to these upper level balconies will also increase the bulk of the development. All of these proposed elevated decks, both at the living and bedroom levels, will allow direct overlooking into my client's private open space. Noise will carry at a much higher level in their elevated locations, and these decks would significantly detract from the privacy and amenity of the neighbouring dwellings. The proposed addition is not of a high design standard. It doesn't address the objectives and controls of the DCP. It's not cohesive with the architecture of the existing interwar bungalow, and nor is it well-resolved contemporary addition. The scale and bulk is unsuitable for the existing house and site, and this is made further evident by the lack of compliance with the height and the FSR provisions. They've not addressed the Waverley Council planning controls. The proposal is well over the height limit for both wall and roof heights. It's over the FSR, and it will cause loss of privacy and loss of amenity. We also support the planning recommendation of refusal for this application. Thank you.
Thank you for your assistance. I'll just see if any panel member has questions to address to you. Mr. Brown.
No questions, thank you.
Ms. Mora.
No questions, thank you.
Mr. Brennan.
No questions, Mr. Chair.
Thank you. Also note that there's, thank you for your assistance, Ms. Hudson, and we will take into account everything that you've put to us on behalf of your clients. Thank you.
Thanks very much.
I note that there's been a written submission received from Virginia Milton for the Bronte Beach precinct that for somehow or other has been put on our list of new submissions, although it's dated the 4th of November 2020, but I should nevertheless mention that as being something received in the last day or so by the panel. The person listed to speak on behalf of the applicants is Rick Deverell. Are you there, Mr. Deverell?
I am indeed. Thank you very much.
Thank you. 3 minutes starts now.
Great. Look, so thank you for the opportunity to appear today. A little bit of background. When we purchased our house, a key factor was the beautiful historical nature of the house. And given that the 1980s first floor addition is dilapidated and frankly is becoming an eyesore, we submitted a DA last year in good faith. And the idea here is to retain the house's character, not knock it down like a lot of people are doing in the area, which we think will enhance amenity both for us and for the local area. I have to say that in dealing with the council, we've attempted to satisfy any changes or requests for more information. However, the council deferral letter, in our view, did not communicate all of the concerns listed in the final report, and as such, did not allow us to respond effectively. Despite this, we are confident that we can amend the design using the full information now available from council and reach an agreed solution. So as such, we request that the application be deferred. In addition, there are a lot of photos in here which we can look through, but we request that the panel join us for a site visit to understand the topography, scale and privacy, which we believe have been presented in an unfavourable way in the report today. Basically, we think there's a lot of factual errors in the report. In terms of the detail, I should say I'm not an expert, I'm an economist, so I don't have the expertise that you guys have. But the main issue strikes me about the height of the roof line. Now, to be honest, again, having no background in this, I was very surprised by that, and there are several reasons for that. First is that the first floor ridge line after the amended proposal is consistent with the current structure, so it's not going any higher. The second one is that the council fully acknowledged that the western wall is fully compliant. It is the eastern wall that is the problem. But of course, the house runs down a hill. So by definition almost, if you have a hill, the uphill part is going to be higher than the low hill part. And that's exactly what happens here. And of course, we want to keep the old house. It has a beautiful 1930s basement with sandstone foundation. And the entry level is 3 metre high ceilings. So what that means is that it's impossible to have a first floor and meet the height limit on that side of the house. And to put it in context, as you can see really clearly on page 234 in the picture, the east side of the house is nearly 2 metres lower than the west side of the house. So it's we've inherited an old house, that is the topography of the area. There's not much we can do about that. So consequently, we believe that it's unreasonable that this has been knocked back. We also note that there are just lots of other houses in the area that are exactly the same as this. If you walk down Gardine Street, almost every house under this interpretation would be more compliant. And indeed, 28. If you look at 28, it has the same hill, so the house one down from us. On the eastern side of the house, it is 3 stories high, but whereas our one is set back on the first floor, that house is straight up. And it's about 10 metres tall. So by this interpretation, that house would be non-compliant as well. We also noticed that the common sense approach that we have provided is exactly what the council recommended for the DA for 48 Brown Street, which was earlier on the agenda today. So, and in that we quote, it says, it was approved despite exceeding the height standard, quote, due to the drop to the southern side at the front of the site, which is exactly what's happening here. So again, we're very surprised with the interpretation. And to be specific, and again, I'm not an expert, in the DA, the Hob calculation uses the natural ground line, but so they suggest that it should use a natural ground line, but in our DA, that methodology was deemed inappropriate. So it just feels like there's an inconsistency. So in conclusion, we feel the proposal is comparable in bulk and scale with the neighbouring properties. You can see very clearly from 234 that the bit at the back you can't actually see from the street because we have gables, beautiful old gables, which we're going to reproduce. So the extension at the back cannot be seen from the street, so it can't possibly increase the bulk. And if you look at the pictures in here looking at the back, we're actually still smaller than the bulk from number 28 at the back because we don't go straight up, we step back. And our house doesn't go back as far in the block as 28 either, so we are indented. So in general, we think we don't understand that particular ruling. And then in terms of FSR, we note that what's really happening here is at the moment we have in the basement area, we have a storeroom, and my wife has a bung knee. So we are trying to get her level access to the washing line. So we're going to replace that storeroom, we're hoping to replace that storeroom with a laundry. And if you count that, if you don't count that as livable space, we're 0.51. So again, it's funny that this has been knocked back when, again, just to look at the agenda today, the Ocean View house in Dover Heights had exactly the same reasoning and the council approved. So to be honest, we're a bit
Mr. Deverell, I don't know what's happened to the timing machine, but you've had a real bonus. So can I ask you to put it together, bring it up into a short summary at the end? Thank you.
So I guess, Mr. Chairman, thank you again for your indulgence. We were a bit surprised. We are very happy to moderate this proposal and to work with council, particularly with the heritage architect. We actually value the heritage aspect of the house. Something has to happen because the top of the house is falling to pieces. And we were a bit surprised both in terms of communication with council and the outcome. So we would like this to be deferred so we can spend more time working with council. And we would also love you guys to come and have a look at the house because there are clearly some dispute about facts. And to be honest, I think it will be very clear that there is no overlooking when you're in the house. In fact, I could literally take my camera here and show you out the back window.
Right, you've told us that.
And show you on the second floor that we cannot see.
You're winding up, Mr. Deverell.
I'm wound up. I apologise.
You're right. All right. All right, I'll just see if there's any questions that the panel might wish to ask you. Can I just ask, I noticed the plans are prepared by a company. How does that occur?
So it's funny because I've never done this before, so I'm a complete novice, but we bought this heritage house, even though it's not listed as heritage, and we hired 2 architects to design a renovation for us. We hired one that was an architect and one that was an architect builder, and the company is Cape Cod. And it was really interesting because the architect, we actually sacked them in the end because they didn't take the old house and complement it. They actually turned it into a new house. Whereas Cape Cod, we think, did a very sensible, kind of very sensitive.
Okay. I think that explains how we get to there. So thank you for that. I'll just see if Mr. Brennan has any questions for you.
Yeah, just a quick question to Mr. Deverell. The existing first floor addition, do you know what the ceiling height of that is? Thanks.
It's got I mean, I'm not an architect, but it's got a cathedral ceiling. So in the middle, it's 2.7, but on the walls, it's only about 1.9. And that's the problem. So to be honest, it drives me nuts because when you're my height, you stand at the window and you're banging your head.
Okay.
Thank you, Mr. Brown.
Yeah, thank you. I can understand now that.
Oh, I'm sorry, Mr. Brennan. I thought you'd finished. Please continue.
Yeah.
Please continue.
No, that's all I wanted to know. Yeah.
Oh, righto. Thank you. Mr. Brown?
I have nothing, thank you.
Thank you. Ms. Mora?
I have nothing to ask, thank you.
All right. Thank you for your assistance, Mr. Deverell, and the observations that you've made will be taken into account. I might add that you can rest assured that each of the panel members has indeed visited the site from the street, but not in the way that you have suggested. But nevertheless, the property has been, they've familiarised themselves with the property and the surrounding properties so that you can be confident about that.
I appreciate it.
And I also might point out to you that the Minister has directed panels to avoid deferrals as a matter of policy in as far as it's practical to do so. But nevertheless, we'll take into account what you've put to us, and the outcome will be published on the website in the next 24 hours or so. Thank you, Mr. Deverell, for your assistance. That brings us to the conclusion of the public session of the panel's consideration. And I'll just wait for an assurance that the public have gone before we decide where to go from here?